Hi, welcome to My Court Coach. I'm Jaylyn and I'm going to be your instructor as we navigate through Form DV-210 Summons for Domestic Violence Restraining Order. So the purpose of a summons is to allow the other party to know that a new filing, a new case has been started against them. So if there is a new case that's been started against them, then it also provides them with some information as to how to respond, the time limit as to how long they have to respond, and just their next steps, whether that's contacting an attorney or contacting the court, but it does provide them with that information. And on this particular summons, it'll instruct them a little bit as to what to do, and we'll get into that in a second. Now, this summons is not something that's ordinarily filed with your request for a domestic violence restraining order. In fact, it's not going to be presented with your request for a domestic violence restraining order. So it specifically says here that if ordered by a judge to use this form, complete items 1 and 2 only. So a judge has to order that you complete this form. This form has been updated as of January 1st, 2020. So this is the form that you would use in case you are unable to serve the other party because they are dodging or evading service. They don't want to receive this paperwork. They possibly know that you have filed a restraining order, and they know that if they don't actually receive the paperwork, then it's as if the restraining order doesn't really exist and they don't have to abide by it. So the court is going to give you alternatives at your restraining order hearing, because you have your temporary restraining order that's going to be granted, and then you're going to go to a hearing. And you're going to go to several of these hearings and get continued and rescheduled for the purpose that the other party is just not able to receive the documents, and we can't deliver these documents by personal service, because that's what the requirement is, that service and delivery has to be done personally. So if you can't do it, it's been several attempts to try and serve the other party, and then the judge can say, okay, I'm going to give you, 2 options to go ahead and serve this other party. You can do a first-class mail, and you can send it to their last known address that they have in the court file. However, if they don't have an address in the court file, then that can pose to be a problem. So the alternative to that is the court will then say it will allow you to serve the restraining order by way of a publication. So the publication would have to be in a local newspaper in which the other party resides. So if they reside in a different state, you'd have to publish those documentations, or I'll tell you in a second what those documents are, in their local county. So you need this form, the summons, and then you would also need the temporary restraining order to also be completed and to be published by the newspaper. So the court is going to allow these 2 documents to be published with their local newspaper, and if an address somehow is able to be ascertained, to be found by the publisher or by you after the publication, then you would need to mail those documents to that address. And then make sure you fill out a proof of service to show the court that, yes, I did complete the service on this other party, and now the court can actually proceed with your restraining order hearing, whether the person shows up to the hearing or not. So there is a cost associated with the publication, and if you win ultimately on your restraining order, then you can ask the court to have the other party reimburse you, or at least contribute to those costs that were associated for publication. Typically, when you have somebody personally served within a certain county, or even other counties, it depends on every county, that service is for free because you are filing a domestic violence restraining order. You do have a restraining order that you're trying to have served. So the court says fill out the first page, your first line, and then the second line. So who's asking for protection, who's the restrained party or the alleged abuser. It's saying that this is a domestic violence restraining order that the person has filed for one, is asking for one against you. You have a court date on this date, time, and department, and then it informs them what happens if they don't go to their court date. So the judge can grant a restraining order that limits their contact with you. If they have children, with the children, it could affect them in other ways, like them not having guns or ammunition, or even it could affect their employment. So if they're in the healthcare industry, for example, that's going to gravely affect their employment. Every industry is different. That is not going to affect everybody in the same way. It's just as dependent on the employment that the restrained party or to be restrained party is in. So if you don't go to your court date, then the court can grant everything that the person in one is asking for. And so I think that statement shows the seriousness of what would happen if the other party just ignores going to the hearing and they continue to evade this whole entire process, which they can do, but the court will proceed on your restraining order, whether that person is going to show up to the next hearing or not. So how do I find out what the person, when it's asking for, tells them to go to the courthouse, and they'll get this DV-100, the request for the domestic violence restraining order. And then where can I get help? There's free legal information at your local self-help center. Do I need a lawyer? You're not required to have a lawyer, but you may want legal advice before your court hearing. For help finding a lawyer, you can visit lawhelpca.org or to contact your local bar association. And the clerk must sign this and date it, and then also have a seal on it. And this will help with the publication of the summons. I hope this helps, and good luck.